Hi everyone. Today we are going to talk about defensive publication and particularly defensive publication in terms of invention and patenting. Why defensive publication is important to understand the landscape of how to stop competitors from filing further patent application in a similar domain. So step number 1 is definitely filing the complete application, which is also called as non-provisional application or a complete specification depending upon the country in which it is filed, with a number of patent claims. Particularly in India, for filing 10 patent claims, there is no additional fee structure. However, when the number of patents or number of patent claims are more than 10 in India, say for example somebody who is filing before the PCT WIPO within 12 months, you need to pay a fee structure in addition to 10. Before WIPO, for 20 patent claims, there is no fee structure, which is additional in terms of whatever the basic fee structure is there. So generally, you will see in the landscape, particularly PCT application, which is Patent Cooperation Treaty applications, that the particular patent has 20 patent claims, and generally it is system maybe 1 to 10 and method is 11 to 20 patent claims. That is one way of doing it. There's no said rule in terms of how many patent claims should be there for a system patent claim or for a method patent claim. It depends on the technology and how the broadest way of technology can be covered in the patent claims. Now coming back to the defensive publication, we are going to see a lot of players filing for patents in respective country through the PCT route, however not filing request for examination. After the amendment in India, particularly from the viewpoint of where the request for examination could be filed within 48 months from the first filing date, has been reduced to 31 months from the first filing date. So it becomes mandatory for the players who really want to have a patent grant in India to file request for examination at that particular stage itself. So a cautious decision has to be made in terms of whether to file request for examination or not. If request for examination is not filed, even then the patent would be published after that duration. Generally it is after the expiry of 18 months from the first filing date. And once it is in the public domain, one is it will come in the patent journal. Second, it will be part of the patent database of that particular country also. So it becomes a shield to avoid competitors to file patent for a similar technology. So defensive publication is going to be more important in 2025 and beyond, taking into consideration the advancement of AI-based patents which are being filed, because when we talk about the software industry per se, we need to look into the aspect of how the technical advancement is taking place. So we are going to see a lot of defensive publication in terms of filing patent applications. Let the patent be published, come in the public domain, and that becomes a shield. So it is very important to see whether a patent grant is the necessity of the hour in terms of 2025 and beyond, or just having a defensive publication suffice the purpose of the company. Thank you so much for watching out the video.
If you found this helpful, don't forget to like and subscribe for more tips on building a solid business foundation. Until next time, keep growing your empire.
Advantage of filing a non-provisional patent application is it is published with a set of patent claims drafted by the patent applicant after expiry of 18 months from first patent filing date.
In patent examination, patent description often becomes more important and has relevance in defining scope of patent claims for several reasons. For processing of patent examination, filing of Form 18 or Form 18A is mandatory.